Ladies and gentlemen, it's been a long trial, and we've all seen how attentive you've been for the past few weeks, and I greatly appreciate that. But we're closing in on the end. Having said that, I'm going to call upon your patience one last time today as I review the evidence. I do promise I won't take a moment longer than I need to, or that I feel is necessary. But this is my last chance to speak with you, and there are a number of extremely important points that I need to say to you before you retire for your deliberations. First of all, it's worth mentioning that I'm at a bit of a disadvantage here, because when I'm done speaking, that's it. I can't get up here again. The prosecutor is going to speak and give you his closing argument after mine. And although I'd like to get up and rebut some of the things, or many of the things he will say, I can't do that. So this is my last opportunity to speak with you. Because of that, as I review the evidence, you may hear me try to anticipate some of the arguments that the prosecutor might make. I'll do that because I hope that when you retire to the jury room and you start your deliberations, you'll ask yourself, what would Harley say about that? Ladies and gentlemen, I'd like to begin by talking about something that is really unfortunate. It's unfortunate because we all like to think of our law enforcement as dedicated professionals, committed to investigating crimes in an absolutely fair and impartial manner. Only that kind of investigation can lead us to the truth. And that's what a criminal trial is all about, ladies and gentlemen, a search for the truth. In this case, we want to know the truth about who killed Farron Green. And our only chance of finding that truth is if we can trust the people in charge of the investigation to behave in a professional and unbiased manner. So we have to ask ourselves, did that happen here? Is that what we saw? Was this an even-handed investigation? Or did the police quickly make up their minds and then just push and push and push until they turned bad evidence into something they felt was good enough to make a charge? Now, one of the functions of a criminal investigation is to seek out and interview witnesses who might shed some light on what happened. But in doing that, it's expected that the police will conduct themselves appropriately. That means they will not intimidate or threaten anyone. We all know from our common sense and life experience that if you pressure someone enough, he or she will say whatever you want them to say. The police know this as well as anyone, if not more so. So let's listen to the way they handled one of the state's most critical witnesses, Keston Miguel. Here are some of the highlights that you heard at trial. Here's the detective talking to Miguel. Quote, and I'm quoting, "Gather everything, all your thought, everything that happened that day, tell us the truth. You're leaving a lot of shit out, and I'm telling you, it's not gonna be good." It's not gonna be good? Ladies and gentlemen, what do you suppose that means? Then they continue, and I'm quoting. Question from the detectives. "I want to start back from the beginning. The beginning because you lied about certain things that we know." And the witness responded, "About what? I told you I didn't see who shot anyone. I was literally looking at the guy when he got shot. I was literally looking at the guy." The detective responds, "And you're going to tell me you hear one shot, something goes in your eye, you're not going to see where the fuck the shit is coming from?" And the witness responds, "I turned, but I turned to leave. I didn't wanna. I didn't stay there." "Didn't you see anybody with a gun?" "No, I didn't know who had it." The detectives continue. "You didn't see anybody with a gun?" And he responds, "It was like three guys standing there." The detective, "Okay, and you didn't see anyone with a gun. You didn't use any, you said you heard more than one shot." "Yeah, it was more than one shot, but how many shots you said? How many shots?" "Like 3. "Okay, and you're You're not going to see anyone holding a gun? No, I didn't look. I honestly didn't look to see who was shooting. And they kept this up, but now they get more aggressive. So let's watch their transition from relatively calm, slightly aggressive, to becoming more and more aggressive. Question. You know that we've spoken to a lot of people. Yeah. And you're still going to sit here and talk your bullshit story about what happened, right? So I'm taking it as you was with the guy. This guy got to be your boy. I mean, you were arguing with your boys. And the witness responds, together? Hell no. The detective continues. Yeah, maybe, yeah. I'm going to go with that. Yeah, because you lying. I'm not lying, says the witness. Why else would you lie? I don't know the guy. But still, the detectives haven't heard what they wanted to hear. So what do? They keep telling him he's a liar. Now, ladies and gentlemen, that's a lot of pressure. So let's listen. The question from the detectives to this witness. And you know their names too. I don't know no names. Street names? Yes, you do. And I cannot be an accomplice, man. I had nothing to do with that. Then why are you protecting this guy? I'm not protecting anyone. You were right there. We got you on video. You're there. I told you I was there. I didn't say I was. I told you I didn't see who shot who. So obviously the detectives, they're not getting what they want. It's not working for them. So they shift to threatening him with his career. He told them, the witness told the police of his interest in joining the U.S. Army, and now it was time for the detectives to take advantage of that. So the detectives continue. Question. Okay, and this is probably your last chance to tell the truth. They ask him, where are you trying to enlist? Like, where do I do my processing? Yeah, that's in, well, what branch of the service? They ask him. Army. Now they respond, okay, that's over. We're going to call them now. Listen to that, ladies and gentlemen. That's over. We're going to call them now. That's over. We're going to call them now. In other words, if you don't tell us something to incriminate Courtney Simpson, then I'm going to call the Army and let them know you're involved in a murder. If you don't tell us something to incriminate Courtney Simpson, then I'm going to end any possibility of you having a career with the United States Army. That's pretty aggressive stuff, ladies and gentlemen. But that's nothing compared to what's coming. Nothing. The detectives see that this witness is not just going to regurgitate what they want to hear. So now they basically threaten to destroy his life. Question. Turn off the video. Lock him up. He's under arrest for murder. Fuck him. And now another detective comes in. You're an accomplice now. Get up. Get up. Get up. I'm tired of this shit. You drive the fucking guy to the car, to the party. You come and get his car and save him. And now you don't want to tell us his name? They continue. Tell him that he's putting you in prison for murder. You hear me? You're going to jail for murder. Fuck you. Piece of shit fucking liar. This is how the police talk to a witness when they don't get what they want. You just fucked yourself. Lying piece of shit. Listen to this, ladies and gentlemen. I apologize for the language. You're going to jail for murder. Fuck you. You're going to jail for murder. Fuck you. Piece of shit fucking liar. Is this what we expect from those who take a vow to uphold the law and to protect us? Is this what we expect from those who are supposed to protect our rights? Right here in America. You know that the detective said it. The state didn't come and say, no, he never said that. We have a transcript I was reading from. It was videotaped. This is what America's about? That the police can threaten to take someone's job away if they don't get what they want? Then they can charge him for a murder they know he had absolutely nothing to do with. A murder. Not not a jaywalking ticket, not a speeding ticket. They tell him, we're charging you for murder just because they don't get what they want. This is in America, ladies and gentlemen. This is the Patterson Police Department. What do you think is going through Keston Miguel's mind? And still, even that violent outburst wasn't enough, so they continued. Did you see Dalla with a gun? Answer, no. Let me repeat that. Did you see Dalla with a gun? This is after they tell him, no army, and we're locking you up for murder. Did you see Dalla with a gun? No. You never saw Dalla with a gun? I didn't see him there. And when you went back to the van, what was the conversation? I just told you about it, yelling and screaming about. You think this is a joke, right? That's what they say to the witness. There's nowhere where he's acting as if this is a joke. This is his life they're about to ruin. I know it's not a joke, man. The guy's dead. I seen that guy alive. Here's how the police respond. What about your life? You gonna throw away for fucking bullshit? I'm not throwing away my life, man. You're all trying to do that. Again, think about that, ladies and gentlemen. The witness believes they are trying to destroy his life. Quote, I'm not throwing away my life, man. You're all trying to do that. Close quote. And whether they are or whether they're not is irrelevant. What matters is that they made this witness believe that. They made him believe that they were trying to destroy him. Think of the pressure of having detectives yelling at you in a closed room, and you believing that if you didn't give them exactly what they want to hear, they will go through with that threat. Think about that. And then they finally make perfectly clear that they were dead serious about destroying him. Remember this? The detectives. You're going to tell me you're in the van and you don't know what the fuck they're talking about? At this point, a second detective says, he's a suspect now. He's got to be read his rights. He can't give a statement now. He's under arrest. Close quote. Think about that, ladies and gentlemen. He's a suspect now. Now he's a suspect. There's no longer any doubt they're going to charge him with murder. And why? They have no evidence against him, and yet they actually arrest him and start the booking process. So what's going on in his mind? He may be going away for the rest of his life for murder. Imagine the pressure. And then and only then does he start to crack. Once he's being processed for murder, he then decides to save himself and give them what they want to hear, something incriminating against my client. Now, ladies and gentlemen, is that the type of trustworthy evidence that you can rely on? Is that the type of evidence you can base a guilty verdict upon? This is the evidence that was drawn out of a vulnerable witness, just as he himself was being arrested for a murder they know he didn't commit. And he knows he didn't commit it. And the Patterson police knew he didn't commit the murder, but did they care? Did they stop to think just how morally reprehensible this all was? Now, obviously, what Keston then told the police is not reliable. It's not the kind of testimony that gives us confidence that we've taken a step further in our search for the truth. Actually, and I apologize for being crude, but it's evidence that is nothing more than pure garbage. But what is more troubling than the unreliability of Miguel Keston's testimony is the fact that this interrogation gives us some insight into the nature of this entire investigation. If the detectives are willing to do this while on the record, with a video camera going, then how much of what they say, how much can we trust of what they do at any other time, especially when no one is looking? Thank God for video, and thank God for being able to catch this police behavior on video. The unmitigated gall of the police to do this, and then to do it on video, as if we didn't learn anything from Rodney King or from any other videos we have unfortunately come to see as despicable behavior on the part of sworn police officers. And that's the essence of this case, ladies and gentlemen. It's a case built upon a fragile foundation, one comprised of a series of statements aggressively extracted from a few reluctant witnesses who, like Miguel, feared for their own well-being if they did not provide the police with exactly what the police wanted them to say. Ladies and gentlemen, that's not a search for the truth. That's just bullying. But it's not only bullying. What it really is a violation of every rule and every tenet of criminal investigation. In fact, ladies and gentlemen, what it is a disgrace. It's an absolute disgrace. And I don't say that lightly, but it's an abomination of all that we hold dear in this country, and it's an affront to what we should expect from our law enforcement officers. But think about what you heard. We have a detective in a closed room with a witness, screaming at him, and excuse my language, he says, quote, "You're going to jail for murder. Fuck you, piece of shit fucking liar. You just fucked yourself, lying piece of shit," close quote. Ladies and gentlemen, how does that happen in America? Why aren't there investigations into detectives who behave like that? And it's not only disgraceful, but it undermines the very case they're supposed to be solving. They have the privilege, the great privilege, that we as citizens allow them of carrying a gun and exercising authority over people's lives. And they have that because we place trust in them. We place our trust in them, believing that they will comport themselves with the dignity that their high office deserves. And yet, what do we have here? Do we see that dignity? No. We see the detective spitting on that trust. You know, ladies and gentlemen, it's really easy to bring a charge against someone if you're going to act like that. In fact, it happens every day in dictatorships all around the world. But here in America, we expect far better from our policemen. And when they act like this, when they act like petty tyrants, then everything they get from their witness is not only ugly and tainted, but it can't be trusted. It can't be trusted any more than the policemen who betrayed their oaths and come off as little more than small-minded bullies who carry guns. And when that happens, then we can't trust anything they give us. Nothing Keston Miguel says can ever resonate with the truthfulness necessary to help us shine a light on this dark and tragic killing. His words are rendered meaningless by the very detectives who were scared to find the truth, and whose sacred charge it is to uphold the law. And the words of the other witnesses are rendered equally meaningless. And so, ladies and gentlemen, the only way they could get anything incriminating about my client from Keston Miguel was to arrest him for a murder he didn't commit. Thus, every single thing that Keston Miguel said was compromised and tainted. It's worth nothing and does nothing to further our search for the truth. Let's continue with Busy. The prosecutor will argue that Busy, or Mario Terrell, saw my client with a gun. The only problem with that is it's not true. And Busy told us that it wasn't true. He came and told us it wasn't true. More important, he told us about the kind of pressure he was under to get him to say it in the first place. Pressure that was just like the obnoxious pressure put on Keston Miguel. Now, ladies and gentlemen, Mario Terrell also has a good reason to feel that pressure. He has a serious criminal history, and he was very concerned that he may be charged with this crime. In fact, he has a gun conviction from 2010 and was sentenced to 3 years in state prison. So he's a guy the police know they can get to. In other words, he's vulnerable, and he knows it. Remember his testimony, quote, "Whoever they picked up implicated me," close quote. Whoever they picked up implicated me. So he has it very much in his mind that this thing could fall back on him if he doesn't play ball with the cops. And now, more than 2 weeks after this killing, and with no leads, the cops are desperate. And we've seen from Keston Miguel's testimony just how willing they are to be heavy-handed when they're desperate. And they know that above all, Busy doesn't want to go back to prison. So they put the heat on him. They have a guy who's scared of death, of going to prison. And they squeeze him like they did with Keston. And not surprisingly, after a while, and remember, this is 2 weeks after the crime, they finally get him to say something incriminating about my client. And why my client? After all, it was Shane and Sean who had been arguing, in fact, arguing aggressively. My client, on the other hand, was trying to calm things down, to be the peacemaker. Yet the prosecution wants you to believe that despite all of that, my client just suddenly decided to pull out a gun and murder a man in cold blood with whom he wasn't even fighting. A man who someone else was fighting with while my client was trying to get everyone to calm down. Does it make sense, ladies and gentlemen? Of course it doesn't. But the cops are intent on pinning this on someone, and so they keep pressuring Busy until he finally gives them something they want to hear. That's how he knows he can get them off his back. That's how Busy protects himself from the implication that he's involved. Remember what he said. Quote, whoever they picked up implicated me. That's what's on his mind, and that's the only thing on his mind. Now, it may be true, it may not be true. Maybe someone implicated him and maybe they didn't. But it doesn't matter. What does matter is that he, Busy, believes it. He believes that he's being implicated in this. And what bigger incentive is there for a guy who's already been to state prison on a gun charge to do something? Even make stuff up to avoid going back to prison, much less on a murder rap. We saw it work with Keston Miguel. We saw how heavy-handed the cops were with him, and we saw that it worked with him. Now they have someone else, even more vulnerable, who believes he's being implicated and knows what the cops want, so the same thing happens. The cops push a square peg into a round hole because that's the only way to close this case. And they're desperate to close this case, ladies and gentlemen. So desperate that they induce a false statement. A fake statement designed and directed by the police who are only interested in closing a homicide case that had come to a dead end. So let's turn for a moment to Willard Buchanan, also referred to as Chicken. Just like Keston and Busy, Chicken also succumbed to his own fears about what would happen to him if he didn't tell the police what they wanted to hear. Like the other two, Chicken managed to keep away from the police for over 2 weeks. Although he was at the party that evening and certainly would have known that the police would be interested in talking to him, he never bothered to come forward to give a statement. He only did so when the police found him. Buchanan, we know, had a criminal history, and the last thing he wanted to be involved in is something like this. So the police used that against him. In fact, he tells us exactly. You remember when I questioned him about his statement to the police? He told us what they said to him. He told us here, at this trial, the detective said to him, quote, "You know you were on probation for domestic violence, and if you don't cooperate, you will be deported," close quote. And Chicken testified here, "That's why I said that stuff." So this guy is not only concerned about going to prison on a murder charge, but also scared to be deported. Think of how much pressure that is, and how willing he would be to say anything that would remove that pressure, remove the fear of prison and deportation. And we can't forget that Buchanan not only has a conviction for assault in his background, but even more important, a conviction for giving false information to the police. And so we have a man with a track record for telling the police things that are untrue. In fact, a man who's been convicted for doing exactly that. And yet the prosecution wants us to believe that this time his statement to the police was truthful. Now, ladies and gentlemen, at the end of the trial, the judge will instruct you regarding the use of prior convictions. You absolutely cannot use them to conclude that a person has a propensity for committing crime. But you can absolutely use a prior conviction to consider that a person who is willing to break the law once may again be willing to break the law by violating his word to tell the truth to the police or in court. The bottom line is that telling the police the truth meant nothing to Busy then, and telling the truth meant nothing to him 2 weeks after the killing. Like Miguel and Busy, ladies and gentlemen, Chicken's testimony did nothing to shed light on what actually happened. It does nothing to move us forward in the search for the truth. But let's just take a further look at what Chicken said in his statement to the police. He claimed that he heard the victim say that it was Dalla who shot him. Is that true? More important, is it even possible? Is it even possible? Let's think about the other witnesses for a moment. Remember Chantress Smith, who's known as Sheree? She was the young woman who went to have a cigarette in the hallway and heard the shots coming from outside. She then went up the stairs to the door that led outside and saw the victim on the ground and ran over to help him. She was the first one there. And she never left him until the ambulance took him away. While she was trying to help him, she spoke with him. And through the entire time she was with him, Farron Green never once said who shot him. If there were anyone who would have heard it, it would have been her, because she was there the entire time. Now, at some point after that, she was joined by her cousin, Shalina Morgan. Shalina had been inside the house, and she came outside after hearing gunshots, and she also went over to the victim. Also, Shawanda Evans went outside and went over to the victim. She told the police that she saw Sheree and Nicole Murray, who was known as Nikki and was the girlfriend of the victim, already out there. Not one of these three women heard the victim say who shot him. Shortly afterwards, Officer Tabor arrived at the scene, and he was with the victim until the ambulance came and took him. Officer Tabor also never heard the victim say anything about him who shot him. And ladies and gentlemen, remember that if there were anyone at that point who you would want to tell who the killer was, it would be a police officer. And yet Officer Tabor never heard such a thing. He did hear, as the women did, the victim express his fear of dying. But absolutely not a single word about who shot him. Also bear in mind that Officer Tabor told you during this time the victim was conscious and coherent. Farron Green was, quote, coherent, close quote, the whole time Officer Tabor was with him. So if Farron Green actually knew who shot him, he would not have had any difficulty communicating that critical fact to the police officer. So to sum it up, we have 5 people around the victim: Cherie, Shalina Morgan, Shawanda Evans, Nikki, and Officer Tabor. None of them even mentioned Mr. Buchanan being present. Not one of those people ever said Mr. Buchanan was close to the victim. And none of them ever heard the victim say anything about who shot him. Let me say that again so it's perfectly clear. We have 5 people around the victim. None of them ever mentioned Mr. Buchanan being present. And none of them ever heard the victim say anything about who shot him. So who are we to believe? The police officer? The woman who was the first one to get to the victim and stayed with him until the ambulance came? Or any of the other women? All of whom have no reason to lie, and none of whom say anything whatsoever about the victim identifying anyone as the shooter. Or do we believe Chicken, who has been convicted of giving false information to the police before, and who, under extreme pressure from the police, including a threat of being implicated in the murder as well as deportation, lied to them again about a statement supposedly made by the victim while he was dying. A statement that only he heard, even though there were 5 other people around the victim, all of whom were trying to help Farron Green, and all of whom were in a far better position to hear anything Farron would have said, including a police officer. The fact is, ladies and gentlemen, that Mr. Buchanan simply lied. Like Keston Miguel, he simply made up a story about the victim that pointed to my client in order to appease the police who were putting tremendous pressure upon him. And again, bear in mind that this is a lie by chicken that took place over 2 weeks after the killing, at a time when the police were desperate to solve this case. On the other hand, the statements made by 3 of the women and the report of the police officer were all made immediately after the incident. So, ladies and gentlemen, there's not a single reason in the world to believe what Mr. Buchanan told the police in that statement. We've seen how heavy-handed they were with Keston Miguel, and it's no surprise to see that Chicken fell prey to those same aggressive tactics that unfortunately are the hallmark of this case. This was a man afraid of prison, afraid of being deported, and he was perfect pickings for a police department that had failed to solve this crime. It's worth noting that the 3 most incriminating statements by Keston Miguel, Mario Terrell, and Willard Buchanan were all taken 2 weeks after the incident. So over 2 full weeks had gone by and the police had basically nothing. That's what accounts for the extraordinarily aggressive tactics they chose to employ. What you heard when they interrogated Keston Miguel was a reflection of their enormous frustration at having gone so long without solving the crime. Regrettably, they chose to close the case by intimidating and threatening a small collection of vulnerable and untrustworthy people long after the killing. They even went to the extent of beginning the process of arresting and charging one of these people who had absolutely nothing to do with the murder, just to get him to say what they wanted. Finally, let's not forget that every one of these witnesses was drunk or stoned. Chicken told us he was drunk on Jamaican rum and also stoned on marijuana. Busy told us he was drinking long before he even got to the party, and Keston Miguel tells us, quote, "I smoke weed in the past, I drink at parties," close quote. Even putting aside all the other reasons to disbelieve their testimony, we have to ask ourselves what kind of mental condition these people were in to even fully understand what they claimed to have seen. It doesn't take a rocket scientist to see that these parties were places for people to get drunk and stoned. There are many reasons to be skeptical of what they may have seen or not seen, but without knowing the full extent of their drug and alcohol use, it's impossible to even know if they were capable of seeing anything, especially when they were not interviewed until weeks after the incident. These are simply not the type of people upon whom we can rely concerning something so serious as a murder trial. Now, the one thing that stands out from all that we have seen and heard is that there is not a single important witness, with the exception of the medical examiner and perhaps Officer Tabor, who can be trusted. I've mentioned before, ladies and gentlemen, that a criminal trial is a search for the truth. But these witnesses, who constitute the heart of the state's case, did absolutely nothing to advance our search for the truth. Whether their collective lack of memory or incoherent accounts were deliberately falsified or not is something we'll never know. But we do know that what they have provided cannot possibly be the basis for finding anyone guilty beyond a reasonable doubt. Ladies and gentlemen, one reason for having trials is so that you're able to actually see and hear the witnesses. That's a lot different than just reading a transcript of what they've said. By seeing and hearing them, you, the jury, get to evaluate their demeanor, to judge the way they act, to assess the manner in which they testify. Ladies and gentlemen, that poses a difficulty for every lawyer in this case, including the prosecutor. That difficulty is simply that after seeing and hearing them, it's obvious that no one can truly rely on any of these witnesses. Now, ladies and gentlemen, I've been extremely critical of the police in this investigation, and in my view, for good reasons. Still, it's undeniable that they simply did not have credible witnesses to work with. In the criminal law, as you've heard, and we will talk more about it later, things have to be proven beyond a reasonable doubt. But the testimony of these witnesses cannot even stand up to the slightest scrutiny. So how can they be trusted to make a determination that requires that there be no doubt based in reason? The answer is simple: they can't. They cannot be trusted. Taken as a whole, they simply are not credible. As a result, ladies and gentlemen, their testimony does not assist us in our search for the truth. On the contrary, their testimony raises far more questions than answers. It paints a picture of events that evening that is far more obscure than it is illuminating. It's a picture that sheds light on nothing. So if we have three untrustworthy people who give us very little assistance in searching for the truth, then we have to ask ourselves if there is at least some forensic evidence that might shed some light on things. There's an old expression in forensics: every contact leaves a trace. In fact, it's out of this principle the field of forensic science was developed. And forensic science is so important, not only because it is so advanced in modern times, but also because over many years we've learned about the unreliability of other kinds of evidence, including eyewitness testimony. In fact, if there's one thing to take away from this case, it is the absolute unreliability of the alleged eyewitnesses who have testified. So, a very crucial question we turn to in any case is, what are the forensics? And the answer here is none. There are none. Absolutely no forensic evidence upon which we can rely upon. There was no DNA here. There are no video cameras that actually help us identify the culprit. And the prosecution has presented no fingerprint evidence. And why not? Why isn't there any fingerprint evidence? We know there were bullets and shell casings found. Remember, I asked Detective Sisti about this. He's the guy who went to that 10-day fingerprint school. Now, that's not exactly a PhD in fingerprinting, but it should count for something. So I asked the detective about submitting the shell casings for examination to the state police lab where they do this kind of work. And what does he tell us? What did he tell us? He didn't send them. He didn't ask for them to be sent. He didn't even know who was running the investigation. He didn't know who the lead detective was. And what was his excuse? He actually told us it was because there's only a 1% chance of getting a match. He told you that there was a 1% chance of getting a match. A 1% chance of catching a killer. But you know what, ladies and gentlemen? That's not enough for him. Because this murder trial doesn't mean that much to him. Who killed Farron Green doesn't mean that much to him. I asked him if he ever bought a lottery ticket, and he said no, he never bought one. Well, maybe that's true, but I'm having a hard time believing it. But even if he is one of a tiny number of people who never bought a lottery ticket, that's giving him way too much credit. Lottery tickets, after all, are long shots. 1 in 1,000, 1 in 1,000,000, 1 in 10 million. But that's not what we're talking about here. This, if we believe him, is 1 in 100. How could you not submit a piece of evidence where there is a 1 in 100 chance of catching a killer? Is that really what they taught him in that 10-day school? Does that seem likely? If they really did teach him not to submit that kind of evidence, then the Patterson Police Department ought to get their money back for that 10-day course. It certainly doesn't take any kind of special insight into forensics to know that if there's a 1 in 100 chance, you check it out. You do something about it. You don't disregard any possibility of finding out who killed Farron Green or anyone else. Every door an investigator knocks on has a small chance of success. If a cop canvasses the neighborhood, what are the chances that he finds something with important evidence? They're certainly not great, but it doesn't mean he doesn't do it. Ladies and gentlemen, this is just yet another example of the police not doing a professional job. If they had found someone's fingerprint on one of those shell casings, we wouldn't be here today. More importantly, my client wouldn't be here today. The fact is that this entire investigation is a disgrace. For some reason, it was designed to get my client and anything that might prove otherwise, like the obvious step of having shell casings tested for prints, that was just tossed out the window. In the end, ladies and gentlemen, any lawful verdict must be based on facts and not speculation. There's no principle in law more important than that one. But in this case, because the factual evidence is so weak, the prosecutor's case has been built entirely upon that speculation. What evidence does the state have against Mr. Simpson? Ladies and gentlemen, one witness who supposedly saw my client with a gun at the party, who then later denied it at trial. One witness who said the victim pointed out my client before he died, but nobody else heard it. And none of the other witnesses ever even saw him there. And another witness who claimed that my client had a gun outside the party, but he also comes in and disavows his own statement. And every single one of these three were intimidated by the police, who had their minds made up and were not going to take no for an answer. In Keston Miguel's case, they just browbeat him. With Chicken and Busy, they knew they were possible suspects. There's not a clean, believable witness in the entire bunch. And that's it. There's no more evidence against my client. So how can a case be built against him? There's only one way, and that is to engage in speculation, to replace hard facts with imaginings, to draw spurious connections and invent evidence that simply does not exist. The state has resorted to this type of speculation throughout this case because there are no facts, no hard facts, no reliable or trustworthy facts that prove beyond a reasonable doubt that Courtney Simpson fired any gun that night, much less the gun that killed that man. Ladies and gentlemen, those facts don't exist. There's simply nothing, no facts whatsoever, no evidence at all that can stand up to the slightest scrutiny. This case that looked so strong when the prosecutor gave his opening statement has been exposed for what it really is, a case that is built on sand. Ladies and gentlemen, when you go back into the jury room deliberating, I'd like to ask you to ask yourselves a simple question. What other decision in life would you make and feel confident in based upon the degree of trustworthiness of the testimony we've had from these witnesses? Would you make any decision in your life based upon this kind of testimony? Would you buy a used car based upon the testimony of those witnesses? On the trustworthiness of this evidence? Would you put a mortgage down on a house based upon this kind of testimony? I submit to you, ladies and gentlemen, that you wouldn't make any important decision whatsoever based upon the kind of evidence we've heard in this courtroom. How could you? What kind of confidence could anybody have in the veracity, the truthfulness of what you've been told? And yet, the prosecution wants you to make the most important decision imaginable, a truly momentous decision, one that affects the life and freedom of my client. They want you to make a decision to find him guilty of the most terrible crime, and to make that decision based upon the incoherent, deceptive, and untrustworthy evidence that was forcibly and aggressively gathered long after this case should have been solved. Ladies and gentlemen, it cannot be trusted. There is simply no credible evidence to support a conviction, no credible evidence to justify finding my client guilty of this terrible crime, and certainly no credible evidence of the kind necessary to meet that high standard of beyond a reasonable doubt. Let's talk about that burden of proof briefly. It may be the single most important legal principle in any criminal trial. The judge will instruct you that it's the prosecutor who has the burden of proof. We don't have to prove anything, ladies and gentlemen. We're the defense. In America, they have to prove everything, and they must prove it beyond a reasonable doubt. And yet, I think it's fair to say in this case, the defense actually has proven that my client is not guilty of these charges. Every piece of evidence presented by the prosecution has been discredited or rendered meaningless. Ladies and gentlemen, you've heard me argue strenuously, emphatically in fact, that these three alleged eyewitnesses cannot be trusted. You had a chance to listen to them and evaluate them the same way you would anyone else in life. I would submit to you that it is clear that their testimony was, at the very least, absolutely unreliable. But let's, just for argument's sake, ask ourselves, not whether they lied to the police, but only whether it's reasonably possible that they lied or were mistaken. Is it a reasonable possibility that they lied or were mistaken when they made those few incriminating statements that the prosecutor will rely on? Well, if we answer obviously, it seems absurdly obvious. Yes, of course, it is reasonably possible that they lied or were mistaken. It's reasonably possible. Now remember, I'm not asking you if you're certain of it. I'm not asking you if you're firmly convinced of it. I'm not even asking you if you think they probably were lying or mistaken. That's not what I'm asking you. Ask yourselves, if you believe that there's a reasonable possibility that they lied or were mistaken. That, ladies and gentlemen, is the most important question in the case. And I would ask you, ladies and gentlemen, when you go back into that jury room, to ask yourselves, is there a reasonable possibility that those witnesses, Keston, Chicky, and Business, lied? Is there a reasonable possibility that what they told the police was not true? Think about the pressure they were under. Think about whether the testimony they gave in court was consistent with what's on their statements. Think about whether lying or being mistaken to the police means the same to them as it does you. And then ask yourself, if there's a reasonable possibility they were lying or mistaken. That's such a critical question, because if the answer to that question is yes, that there's a reasonable possibility that they were lying, then ladies and gentlemen, that is a reasonable doubt. If there's a reasonable possibility that they were lying, that is a reasonable doubt. That alone, the existence of a reasonable possibility that those three men gave statements that were untrue to the police, means that the state has not met its high burden of proof and the verdict must be not guilty. Ladies and gentlemen, there's a very good reason for that very high burden of proof. We have here a tragic situation. The senseless death of a human being. Nothing is worse than that. On that point, no one disagrees. No one should ever attempt to diminish the pain and suffering felt by the family who has endured such a tragedy. And we would all be less than human if we were not tempted to allow passion to seep into our thinking. A passion to set things right, to find justice for Mr. Green and his family. But just as there is a desire for justice, we cannot dispense it if it means creating another injustice. The evidence shows that my client did not commit this crime. He should not be sacrificed because we want justice for someone else, because we want closure for a tragic case. His life has meaning too, and it should not be destroyed simply because we understandably feel the need to do right by the victim. As the judge will instruct you, there can be no place for any of that in your deliberations. Is that because the law is indifferent to the tragedy that has occurred? Absolutely not. But as I said to you in my opening statement, we are not here to decide whether or not something terrible and tragic happened. We all know that it did. But we are here for a different purpose. We are here to answer a far more narrow question. Did my client kill that man? The state has brought these charges against him, and now they must prove them. In a free society, the burden of proof must always be on the one making the accusation. And as the judge will tell you in his charge, the state's function in our system of justice is not just to prove guilt, but to prove guilt beyond a reasonable doubt. That's the standard for any jury in a criminal case in America. You have to decide if there's a reasonable doubt as to the defendant's guilt. You must search for reasonable doubt, which, as I've said, could mean a reasonable possibility that the witnesses gave dishonest or mistaken statements to the police. Such a reasonable possibility constitutes reasonable doubt, and reasonable doubt requires a verdict of not guilty. Ladies and gentlemen, we all selected you because we had a sense about you, a belief that you would follow the law and listen carefully and evaluate all of the evidence. And that's what we ask you to do now. Review all the evidence. Listen to the evidence. Hold these questions up to the light of your own common sense. And ask yourselves, is this the kind of evidence I can rely on? Is this the kind of evidence I can trust in order to convict a man, an innocent man, of the most serious charges imaginable? When you're done with that review, ladies and gentlemen, when you've held this weak evidence up to the strong light of common sense, I feel sure you will come back in here and give us a true verdict, one in which you simply say that the state has not met its burden. It did not meet its burden of proving my client beyond a reasonable doubt. Ladies and gentlemen, they didn't prove it, and they didn't even come close to proving it. And I'm confident that you will find that the only truthful, appropriate verdict in this case is one of not guilty. Thank you.
Thank you, Mr. Breite. Mr. Camilli?
Judge, I'm ready to go, but maybe everyone will take a 5-minute break to go past.
You all wouldn't mind retiring to the jury room for 5 minutes, take a quick break, and then we'll bring you right back out.